Good afternoon. Hello, everybody. So we are proudly the last panel of this wonderful conference. And I'm so glad that you're here, all of those of you who are here in person and those of you joining us online, thank you. So first, thank you, AAAS, thank you, Joel, Ellen, and Teresa for this opportunity to participate in today's conference and for including this exciting topic among the very important topics that were covered over the last 2 days. My name is Sarah Chu. I'm the Director of Policy and Reform at the Perlmutter Center. We're a center at Cardozo Law School that is wholly dedicated to forensic science education, training, litigation, and policy work. We also represent clients who are pursuing clemency, and those with claims of innocence whose cases involve forensic science. So, over these past 2 days, we've had amazing talks and discussed how we should treat evidence before it gets to court, how it should be handled in the court, and this panel has a special charge of contemplating what happens to evidence post-conviction. And Judge Gertner referenced it yesterday as the problem with changes in science. And so change in science laws and court rules, very briefly, offer people a path to challenge convictions that were gained by scientific evidence that present-day research has shown to be less accurate, to be flawed, or if an expert retracts or takes back their testimony from the past. And I have the distinct honor of moderating this panel of experts who can provide us with lived experience, research, policy expertise that can guide us to better understand what happens when science changes post-conviction. And I hope you'll forgive the very brief introductions I'm going to be giving. You can find the full bios of these panelists, these distinguished panelists, in the program online. But I really want to preserve time for what I think will be an exciting Q&A session. So today we're going to start off with Dr. John Morgan. He's going to talk about research related to forensic science and wrongful convictions. He's internationally recognized for his work in forensic science and other police support technology through leadership roles at NIJ and at RTI. His federal service includes senior executive positions at both DOJ and DOD. And relevant to our conversation, he received a Service to America Medal for his role in implementing the President's DNA initiative. So through that work, he increased capacity of forensic laboratories to conduct DNA testing and also made so many more DNA exonerations possible. Kristine Bunch will follow Dr. Morgan. She is a powerful advocate, and you'll hear directly from her today. And she works with the growing community of exonerated people. She co-founded and leads Justice for Just Us, which connects exonerated individuals to social and medical services that helps them rebuild their lives after exoneration. Kristine is a survivor of a wrongful conviction, and she's among the 3,383 and growing number of people whose innocence has been formally recognized by an exoneration since 1989. She's also an advocate for change in science laws, and I'll let Kristine tell you more about her case and how her flawed arson evidence in her case stole 17 years of her life from her and her family. And finally, we'll hear from Rebecca Brown. If there is a law that prevents or reveals wrongful convictions in your state or assures compensation for the wrongfully convicted, then you know Rebecca's work already. She is the founder of Maat Strategies, and after 18 years of leading policy work at the Innocence Project, she's running this political strategy organization now. And during her tenure, working on wrongful conviction policy, she led or advocated for the passage of nearly 300 state laws across the country and numerous federal laws. She's also led the passage of most of the nation's 7 and hopefully 8 by December, change in science statutes or court rules. So we're especially fortunate to have the brain trust of the subject of this panel right here for you today. And so let's welcome the panelists, and we'll start with Dr. Morgan.
Okay. So I'll be talking in an obtuse way about some of the research I've just conducted on wrongful convictions. I did a study for the National Institute of Justice on 732 cases of wrongful conviction associated with false or misleading evidence. So I'll direct you to the Journal of Forensic Sciences for that particular piece of research. But today I want to really focus in on this idea of changed science. And by changed science, I think we need to make sure we're clear about what we're referring to here. Because in this room, we might think of science as foundational reliability, as PCAST would put it. But when we're talking about changed science in this context, we're talking about science as it existed in a particular case at trial. That is, the way in which the science was actually layered by the system with respect to how it was applied and how it was used, how it was communicated in that particular case. And one of the things that the experience of wrongful convictions clearly demonstrates is that those system issues have a very fundamental impact on the reliability of the science. And therefore, although we care very much about the foundational aspects of science, we also care about this other aspect, which is the system aspects of how the science was actually applied in the case. So then we first need to distinguish what we would call bad science from a foundational perspective. Sometimes when we talk about the changed science statutes, they're called junk science. I'm not a big fan of that term, partly because as a scientist, I'm aware that some things that we now take as settled science were once considered junk science. Continental drift, the contribution of Helicobacter pylori to ulcers were once considered junk science. And so I prefer to say that there is science that has appropriate empirical validation and science that does not. And there has been a fair amount of science, of that kind of science without foundational reliability that has been introduced in wrongful convictions and in criminal justice more broadly. And I have my laundry list that I'll mention: fire investigation, as Kristine knows, infant trauma and other types of pediatric abuse. Compositional bullet lead analysis is definitely a key one. We've talked a little bit about bite marks. I'll mention another little aspect of that I think is worth saying. Dog scent lineups, actually, is one that I think is not talked about enough. And statistics. There has been a lot of rather poor statistical characterization done in the courts, and those are relevant to our conversation today. But there's also been good science. So in my study, I found clearly 621 cases in which I was able to identify the forensic errors in those cases. Of that 621, 470 of them could have been impacted by better science. And now we're used to that being DNA. And certainly, as Sarah points out, DNA was relevant in a lot of those cases. But DNA was only one element of how that can manifest. So for example, Raman spectroscopy manifests in seized drug cases as being better than colorimetric drug testing. Mass spectrometry has largely displaced the use of flame ionization detection in a lot of chemical analyses, both in fire and in drug analyses now. The automated databases, such as automated fingerprint identification systems and palm print identification systems, have been enormously helpful, but also, and I think more relevant today than ever before, and why changed science is important, are the standards that are science-based standards. That is, the ability to identify both methods and interpretation approaches that have a solid scientific basis. Because right now, DNA is becoming less and less important from a post-conviction perspective, because there are fewer and fewer cases where DNA was not available at the time of trial. And so there are more and more cases that are coming forward now where the real issue is, was the science interpreted properly in this case? Was the evidence interpreted with good with appropriate standards, science-based standards? I'll give a few examples of some categories for this, just to clarify this to some extent. So for example, prior to the use of DNA, we had hair and serology. And hair and serology had several weaknesses, one of which was that they weren't that probative. That is, their ability to be sensitive and selective relative to the populations that might be included were rather poor, especially in comparison to DNA. And so even when appropriately applied, serology often was unable to prevent a wrongful conviction. That was later overturned by DNA. That's the most simple form of changed science. However, there are other ones that are involving misinterpretations. You can have misinterpretation by the examiner. Oftentimes, even though, for example, serology being a good example, there was excellent science, actually, behind serology. As strong a scientific foundation in serology as there is for any discipline that is around today. But the examiner could still misinterpret that analysis. That is, they could take it was very easy, because of aspects of masking and other things like that, to discount the value of, for example, an exculpatory interpretation of the serology. And that was oftentimes the type of misinterpretation you found in a wrongful conviction for many, many years. The flip side of that is how the system used that evidence as well. So in many of these cases, there was actually an exculpatory interpretation that was put forward of the hair and serology. That is, for example, the only hairs that were found, or foreign hairs that were found at a crime scene, were hairs that could not be associated with the defendant at trial. That is, at least at some level, exculpatory. And so the ability of the system to recognize what is truly exculpatory information is just as important as the ability for that examiner to be able to apply the interpretation in an objective way. One example of this that I want to highlight is actually in the fire area, because the misinterpretations of the science in fire are much more complicated than what is generally recognized. So NFPA 921, which came out in 1992, established a basis for scientific interpretation of fire scenes. However, it is not oftentimes known that there were what was considered at the time science-based guides that were put out by the old National Bureau of Standards in the fire area. And they were examiners were trained to that, and they accepted that, and many of them held fast to the incorrect information that was in those guides, even after the advent of 921, and that was crucial to a very large number of wrongful convictions involving arson throughout the 1990s, even into the 2000s, as some of the old guard was still in place. And so it raises this issue with respect to what we're going to consider to be scientific consensus, because they thought that they were doing a good job building the scientific consensus, when in fact, to some extent, they were deferring to the practitioner lore more than they were to the empirical basis that they had for fire interpretation. So there was improvements in the empiricism of fire interpretation, certainly throughout the 90s and since. However, there was also this issue where we need to have standards that are trustworthy, that are built in a trustworthy way, and they need to be implemented. This is a key lesson from all of the wrongful convictions work that I did. Finally, I want to do two more things. First, I want to talk about cutting-edge experts. I call it beware the black sweater. If you remember, Steve Jobs used to have the black sweater on, and if you remember, ever see a picture of Elizabeth Holmes? She had the black sweater she always had on, and everyone wants to be Steve Jobs and be like the guru, right? And this is actually something that you've seen in many wrongful convictions involving science that had not been appropriately validated. And I'll give several examples of this. One is the UV visualization of bite marks and other bruises. Michael West is notorious for his involvement in a large number of wrongful convictions, where he was applying what I honestly believe he was seeing, which is that he thought he could see bite marks that nobody else could see. And he became an advocate for that technique in a way that was very questionable. But he's not alone in that. There's another one, Arnold Melnikoff, who was the originator of the Montana State Lab. and who gave incorrect testimony in a number of hair cases, saying similar to what we heard in some of the cases before, where it's like, 1 in a million that this was somebody else. And he actually had done research on sagebrush, where he had said, well, I can trace the genetic characteristics of the sagebrush to their species. And I can say, oh, this is where that sagebrush came from. And if you read his master's thesis and you read his testimony, you can see he was just really misapplying the lessons he had learned from a completely different field. That is, nobody ever told him how to think about the limitations of science and to think about even the limitations of his own research. And so when he went in, they had a kind of a bias toward the idea that, yeah, he could see that individualization using hairs in a way that, he was leaving the rest of the field behind because he felt he was way ahead of them because of his background in research. Another example is shoe print individualization. Louise Robbins, I don't know whether she's lost to the mists of history or not, but she shouldn't be. She was an anthropologist at UNC Greensboro, and she actually had done a lot of research of ancient sites. And some of her scientific colleagues were very skeptical of her work. She believed at one point she could say, well, this person lived X number of years ago, and they were this tall, and they were 5.5 months pregnant, and I can tell that from their footprint. And she wound up, and you say that in a scientific setting, and it's at least acceptable in the sense that you're putting something out there as a hypothesis, really, that can be disproven. You start putting that into court, well, what she wound up doing in that sense was saying, I can tell that this footprint was made by John Morgan or whomever to the exclusion of all others in the world because I am able to make that interpretation. She was this cutting edge, she viewed herself as a cutting edge expert where the field needed to move ahead. And I caution, even in the use of, for example, statistics. I'm a big fan of the use of statistics. I worry that when we move too fast into new areas before we have done the foundational work, that we may mislead juries in the same way that Louise Robbins did. We may become too enamored with the idea that we can do something to improve without necessarily having the foundational aspects to be able to say, do we understand the phenomenology well enough in this particular instance to be able to give a valid and reliable statistical interpretation? So I don't know whether I'm out of time because I could talk to more. I have one more point I'd like to make. Okay, so in terms of the actual changed science statutes, all of this is relevant as well. So the landmark case is the Neil Robbins case in Texas. And that was a case not where the science had changed a great deal. It was an infant abuse case where a 17-month-old girl died. And there were 3 main issues. One, whether the injuries were caused by abuse or by CPR attempts to revive the child, the signs of asphyxia, and whether prior injuries were accidental or intentional. And the medical examiner originally said that it was homicide, had made the determination that it was homicide. Later said, based on what she had learned in the post-conviction, she said, I now feel undetermined is best for this case. And most of the experts who weighed in never said that it was an accidental or natural cause. They weren't willing to go that far, but there were this one and another expert later on who was willing to say that it was a homicide case. And the problem was not that to some extent there was better science, but not that much really. The problem really was that this was an expert who went well beyond their training. And so they were on the other side, the other extreme in some respects from that cutting edge expert, somebody who was such an expert that they became a little arrogant. And then you have the other side of this where you have the expert who doesn't have the training necessary to be able to make the determination. And so she basically said, I made a homicide determination without the adequate scientific basis for doing so. So not that I can say this was definitely one thing or another, that in fact sometimes science doesn't have the answer. Sometimes that is the right answer, is that science just can't tell you the answer in this case. And so undetermined was the appropriate answer. As it turns out, the courts, just like they used to do for DNA, by the way, it was very common when the DNA first came in as being a post-conviction reality, like we can actually exonerate people, that unless it actually said, well, that's the individual who did the crime and could actually identify them out of the population, then it was considered, well, you know, was it Barry Scheck? Had the famous thing where it says the prosecutor always found an unindicted co-ejaculator who contributed the DNA in this case. And the same was really true here fundamentally from a information perspective, in terms of the basis here. And that is, merely saying that it was undetermined was not enough to convince the court that the science had changed in the case. That is, it did not exonerate the person, Neil Robbins specifically. And that is why, and I know we're going to hear it more, why in Texas's particular case there was a need for a changed science statute. The idea that the science has changed fundamentally in the case, but even and sufficiently to say that the person did not get a fair trial, even if the science is merely coming back and saying, we really didn't know. We misled you by telling you we knew. And that should be at least sufficient to say at least that the science has changed. There are a number of other cases that involve changed science in Texas. The only other one which was not a changed science case, but which I wanted to highlight today because I think we're in the middle of some new technologies in science coming forward that are worth paying attention to. So one of the few cases involving firearms examination and a wrongful conviction that was overturned is the Persley case here from the last couple of years, which really turned on the improvement in microscopy. And it really is not well recognized, although the NIST has done some amazing work in this area. But firearms examination is undergoing an incredible transformation right now. And the Persley case was based first, there was some examiner variability where there were changes from one examiner to another with respect to what their conclusions were about whether the evidence bullets matched the source that was associated with Persley or not. And so there was that issue, but that issue was never enough really to say that to call into question the evidence. The more important one was that eventually better technology came in that could be applied that showed that the cartridge casings in particular in that case didn't match the presumed source that was associated with Mr. Persley. And that is really the key element of what caused what led to his exoneration. So I think having a broader view, if I can say, a broader view about what we mean by changed science, what we mean by the ability to say what level of expert opinion has changed, what type of technology has changed, and what kinds of science-based standards were applied, and finally, how the system used all of those other elements appropriately or inappropriately, all can constitute some form of changed science. And I would encourage all of us to think in that broad term, in those broad terms as we examine these issues and examine not only cases, but also policies related to forensic science going forward.
Hello, everyone. My name is Kristine Bunch, and I am from Indiana. And in 1995, I was a single mom, working, going to school. I had a beautiful 3-year-old son named Tony. And one morning, I woke up really early, and my life was forever changed. My home was on fire. And when you first wake up, it takes you a minute to realize what's happening. Remember I told investigators it was foggy in there. but it was really smoke. And when I realized what was happening, I'm up trying to get into my son's bedroom, and there's fire in the doorway, and I can't get in there. So I'm thinking, okay, you smother it. So I go to put something on it to smother it, and it just went up in my hands. You're in panic. You're in a fear like you can't describe. And so my only thought was, I've got to get in there. So I ran out screaming and picked up his tricycle and busted out his bedroom window and tried to climb through the window. My neighbors pulled me out and told me that I had to wait. I wasn't about to wait. They stopped me from running back inside because I couldn't believe they were telling me I just had to give up. And they were like, you know, the fire department's gonna be here. When you're waiting in those moments, I know it was minutes, it feels like hours. They put me in an ambulance. They're, you know, outside doing things, and my mind is racing. You know, are they gonna get him? Is everything gonna be okay? What do I need to do? And they open up that door and I say, did you get him? And they said, yes, we've got him, everything's fine. Okay, I'm fine at that point. Take me to the hospital. It wasn't until I got to the hospital and I'm telling my dad everything that happened and that I wanna be in a room with Tony. I was like, I can stay there with him till he gets better and everything will be fine. I'll figure it out. I just need to be with him until he's okay. And my dad was the one that had to tell me that I lost my son. I looked at him and, you know, you don't want to believe it when somebody tells you something so horrible. And he had no sooner said that, and the first detective was there to get my statement. And I said, oh, yes, sir, I'll give you a statement. And my dad said, no, she hasn't even been admitted to the hospital yet. You're going to wait. So 2 hours later, he came back along with some other gentlemen to tell me that they had went in and scientifically proven that the fire was an arson. It couldn't have been anything but. The evidence was overwhelming. And at that point, he wanted to know who could have come into my home and did that. So essentially, I named my family and friends because nobody else really came into my home. So all the people that could have comforted me and helped me, I'm now looking at them like they're suspects. I decide, you know, they're gonna figure this out. Obviously, you know, somebody came in to do this. They're interpreting the science. 3 days later, I'm arrested, charged with arson and murder because I was the only person there. And basically in the 90s, if you survived a fire and somebody else didn't, 9 times out of 10, that person is going to jail. They're going to think something's wrong, that one person survived and one person didn't. So I'm arrested, I'm sitting in jail, and I'm hearing all kinds of things from my family, from the attorney, talking about fire science, talking about test results that we're waiting from the alcohol, tobacco, and firearms. And I said, okay, I don't understand any of this. I mean, I've never been in trouble with the legal system, let alone fire science, trying to figure out what you're talking about. So they tell me, oh, we've got it covered. We're gonna take care of everything. My trial, a lot of that went by in a blur. I was pregnant with my second son. I'm still in shock and grieving, but I remember the important things, like my prosecutor saying, we don't have to prove a motive in the state of Indiana in order to prove murder. And that's good because this case doesn't have one. It's a circumstantial case based on science. And then, you know, the investigators took over and talked about how when they walked into my home, they could see burn patterns on the floor and concrete spalling and alligatoring and window charring and pore patterns and V patterns. And I'm listening to this thinking, that sounds really scientific. The ATF took the stand, and that chemist said that he had taken 10 samples, 3 of which had tested positive for something that he couldn't totally identify. It was either kerosene, Jet A aviation fuel, or No. 1 fuel oil. He said he found 2 traces in the living room and 1 in my son's bedroom. I was found guilty. I was sentenced 60 years for murder, 50 for arson, and my judge ran them concurrent. I got to the prison. I am almost 7 months pregnant, and I'm trying to figure out how I got here and what I need to do to get out of here. I was blessed. My family took my son. I had access to a law library, so I was able to learn about fire science. And trying to navigate that is like reading stereo instructions. I mean, it's a lot, and I think we make it way harder than it has to be. So I was probably in prison 5 years before I received a wonderful article about some arson investigators, and they talked about the scientific myths around arson. Pour patterns, V patterns, concrete spalling, alligatoring, pour patterns, all these things. And I was like, how can that be a myth? I was convicted on those very things. That's not a myth. They convicted me. So I'm doing the normal thing in prison. You write letters. You write letters to everybody you can, especially if you're innocent. You want somebody to step up and help you because nobody's going to listen to you in prison. And so I wrote every organization I could find, every lawyer I could find. Some of them were tax lawyers. If it said attorney, I wrote them. I wanted somebody to know that I knew that I didn't do this, and I didn't understand how this science could convict me. So, during my education on my own, and with the help of some people that I could ask questions of, I discovered that it wasn't true that the gas chromatograph could not identify the accelerant used in my son's room and the living room. That was, he told me, supposedly to mislead the jury. He said if he's talking about science, true science, the gas chromatograph will identify. He said, you need to get the ATF file. So I tried to get the ATF file. And in the meantime, I'm learning more and more. It wasn't until 2006, I've been in prison 11 years now, that the Center on Wrongful Convictions, which is part of the Innocence Organization, took on my case. And by the time they got there to see me, I had a lot to tell them. I was like, we need the ATF file because the science is wrong. And you need to take a look at those photographs because everything they pointed out, that is not true. That's not an indicator of arson. And I feel like if we could get the photographs, we can disprove a lot of what they're saying. And we need to see those real results. And I remember my lawyer grabbing my hand and she said, okay, now just talk to me like a mom. And I started crying and I said, I didn't do anything. And I need somebody to help me. I would never hurt my baby. And I said, I've got a second one and he's out there growing up without me. And so she said, okay. And they took my case officially in early 2007. They received the ATF file that I was unable to get. They had to get a subpoena in order to get it. And when she pulled it out, she discovered the original report that said no accelerant had been found in my son's bedroom. They had actually found a faint trace in 2 samples in an isolated area in the living room. And it was back over off into a corner where the previous owner had already testified he had a kerosene heater. So those faint traces were kerosene. And it wasn't in the carpet or the carpet padding, it was in the wood underneath. And it had the altered report that had been used to convict me. So at that point, I thought, that's like a Perry Mason moment. I'm going to go home. It doesn't work like that. You have to go in and you have to argue all of the scientific evidence. So we had found some girl named Jamie who was supposed to be a forensic something with fire. I didn't know anything about her. I just knew she was helping me for free. And I told my lawyers, we've got this girl, she's helping us for free. Dr. Jamie McAllister is a forensic toxicologist, and so she does cause and origin on fires based off of the carbon monoxide levels. So my son got to an 80% carboxyhemoglobin. He was dead before the fire even broke out. And she testified that arsons give off very little carbon monoxide. They burn hot fast. But electrical fires that occur in the ceilings or the walls or a hidden area smolder for a very long time, giving off huge amounts of carbon monoxide. Then we had, the electrician that came in that talked about they had wiring, they had a control panel with 4 pop breakers. They had the evidence to look for an electrical fire. They just didn't. They went off of what they could see when they walked in. And those patterns, when you come in from a doorway, that's normal wear and tear sometimes when you just walk in the same way and out year after year after year. You wear it down yourself. So they entered in all that new evidence. I really felt like I was going home. My original judge and original prosecutor took as long as they could and denied it. They said none of that information would have made a difference to my jury. So at that point, we had to go to the appellate court. They picked one case out of 100. They picked my case. My judge went in and argued about the new fire science. And we waited, and normally you have to get, an answer or some kind of response pretty quick to think it's going your way. They took almost a year. And when they did, they reversed and remanded based off of new fire science and the Brady violation for the altered report from the Alcohol, Tobacco, and Firearms. So at that moment, I came home, but I didn't ever really feel exonerated until after we passed compensation in the state of Indiana. That was in 2019. And in order to get it, you have to be termed actually innocent. And so your peers review that. I'm not sure that the judges and prosecutors and sheriffs are really my peers, but I'm glad they reviewed it, and they came back and said yes, they were agreeing that it was an accidental fire. And at that point, I felt like I'd finally gotten recognition. I had finally received an exoneration because they knew that I was innocent. The sad part is there are tons of people that are still writing me letters telling me that they are in prison for fires. And it's the same thing: burn patterns, pour patterns, concrete spalling. If we have the science, there should be no question as to their innocence or guilt. That science needs to be correctly applied, and they should have a way to prove their innocence. Thank you for having me. I'm incredibly honored to be here.
So I'd like to begin my remarks by thanking Kristine for sharing her experience with us. She, at this point, could be just enjoying her freedom, and she's doing this for other people, and just want to acknowledge the strength that takes and our gratitude. So thank you. Kristine, of course, can put a human face on this issue. I'm here to bring us all to a much drier discussion, brought to you by a policy wonk. But misapplied forensic science has played a role in just under half of the exonerations in the United States proven through DNA testing, or post-conviction DNA testing. So it's about 44% of cases, of the DNA set of cases, where we know that there was misapplied science. And Kristine touched on just one of these disciplines, right, arson, fire science, but there have been misapplied science in countless wrongful convictions across multiple disciplines, some of which you heard about also from Dr. Morgan. But before we turn to sort of a more scientific discussion, it's important to really understand the legal ecosystem that not only enables wrongful conviction, but allows wrongful convictions to persist. Producing a wrongful conviction is much easier than overturning one, and that's because the cards are entirely stacked against the innocent person in a post-conviction setting. Most states have laws that theoretically allow for post-conviction claims of newly discovered evidence to be heard in court, but many have incredibly strict procedural bars that otherwise limit someone with a viable claim of innocence based on newly discovered non-DNA evidence from getting back into court. And I say non-DNA evidence because all 50 states have some form of a post-conviction DNA testing statute. I could go on about those forever. Many are limited in substance and scope, but that said, there is a clear mechanism for post-conviction DNA testing in every state, not so with the other sciences. And so, what are those procedural bars? What are those barriers that people are facing? First, statutes of limitation. Many states have limitations on raising claims of newly discovered evidence as strict as 1 to 2 years after the underlying conviction. Cases where evolving science can shed new light on an unjust conviction can take years to develop. Standards of accepted science only change after years of research, studies, and reviews. Statutes of limitation for such cases effectively block efforts, right, to remedy factually wrongful convictions. There are also issues around evidentiary standards of proof. Many newly discovered evidence laws require the petitioner to show that the newly discovered evidence can prove quote-unquote actual innocence, or that the new evidence would probably have changed the result of the trial. Additionally, state statutes often require that the newly discovered evidence not be quote-unquote merely impeaching, meaning that the evidence must not solely seek to attack or contradict witness testimony. At the same time, much of the changed science that must be introduced rests on discrediting the expert testimony put forward at trial. So the common result, therefore, is that courts are reticent to grant motions based on newly discovered evidence, concluding instead that newly discovered evidence is quote-unquote merely impeaching. And even when a standard of proof is reasonable, other obstacles can prevent justice. Once a defendant is convicted, the burden of proof shifts onto him or her in the post-conviction setting to prove innocence. Petitioners who are indigent, are incarcerated for years and years on end, often decades, have little access to the resources required to carry such a burden of proof. Kristine is obviously an exception, just diving deeply into the science, but still all of those obstacles there. Additionally, many states do not provide a right to counsel after the direct appeal. All of this taken together demonstrates the incredible uphill battle that people face once they are already convicted but are wanting to present these claims. The legal system, after all, is designed for finality and efficiency. From the front end of the system, right, where we know, depending on your jurisdiction, between 95 and 99% of cases are pled out, and all the way through the post-conviction setting, where the innocent people face just a complicated web of laws and an extremely harsh post-conviction legal landscape. And of course, there is no finality for either the wrongfully convicted innocent person or the victim of a crime if the wrong person was convicted. If in fact there even was a crime. In this case, of course, there wasn't. Sometimes other post-conviction remedies are possible, but those mechanisms don't match the claim. So for instance, in the absence of a change in science statute, oftentimes people are forced to contort themselves into other claims that are available to them, things like, a constitutional claim that you had ineffective assistance of counsel for failing to bring forward, certain scientific information, but oftentimes, that's not adding up. The courts are rejecting those claims. So in a state without a law like this, that person is just out of luck. So given this legal reality, the innocence community really worked to create statutory mechanisms to enable innocent people to get back into court to prove their innocence when science has changed or evolved, or when experts have repudiated past testimony. And now 7 states, California, Connecticut, Michigan, Nevada, Texas, West Virginia, and Wyoming, have enacted these laws. I should note that Michigan was actually established through a court rule, not through the legislative process. So there are other mechanisms available to create these frameworks. And consider really what can happen in the absence of these laws, right? You just heard from Kristine that she had to go through this entire process in the courts, and the circuit court initially rejected her claim. And the Court of Appeals might not have taken her 1 in 100 cases, right? So it's very likely it never would have even been heard, and that would have been the end, right, without a mechanism. And so, had a change in science law been in place, she would have avoided potentially years in prison. And of course, most courts do not make these types of findings absent a change in science mechanism. When people oppose the creation of these mechanisms, they hang their hat on the concept of finality. And, I encourage them to think about Kristine Bunch and so many people like her. I should note that Texas and California are the 2 most populous states in the country. They have had these mechanisms in place for years. The court system wasn't overrun by claims. And what I always tell people too is, and lawmakers, policymakers in particular, is that people will file claims anyway, right? There are other mechanisms. It's not as though claims are not going to be filed. Creating a change in science statute simply directs the court to look at the right lane of the highway, to look at the claim right in front of them that they should be looking at, not a contorted claim that's been shoved into a constitutional claim or some other possible legal avenue for relief. So I will close by just saying it's really, truly thrilling to be here with all of you today, because all of the good people here have a role to play in helping to move other states to adopt these mechanisms, and I'm happy to discuss more of that during Q&A, but thank you.
All right, so excited to move to the Q&A portion. Joel, how much time do we have? Okay, we'll make this quick then. So Kristine, in your remarks, you talked about having heard from people who are currently incarcerated about arson cases, and you're deeply networked with the community of freed and exonerated people. Is there something about wrongful convictions and forensic science that maybe we haven't touched on today, or is a kind of lesser known issue that you'd like to talk about?
Can you hear me now? Okay. So of the 3,300 and some that have been exonerated since 1989 that are on the national database, only 286 of them are women. And of those women, 70% of them, no crime occurred. So I feel like science plays a detrimental role when it comes to the convictions of women, and these statutes can help get more women exonerated. That's something that most people don't talk about. The big focus has always been DNA. But in the other sciences, I feel like women are lost and they need to be brought to the forefront.
And John, today we talked a lot about a statutory change. And sometimes, the thought of going to your legislature to change a law seems really daunting. Are there any other structural changes or any other strategies that exist to improve the reliability of science?
Well, one thing to keep in mind about all of these issues is that we sometimes think, well, if we can just get the crime labs in line, everything will be great, right? And the crime labs have actually made some progress in recent years. The level of accreditation in public crime laboratories is night and day with what it was 20 years ago. However, almost none, for example, of bite mark examiners were in a crime lab when they testified in these wrongful convictions. A lot of the forensic medicine people who testify in pediatric abuse cases sometimes they've never even done any other kinds of forensic work or testified in a case. Many people working in fire investigation also are not. And so there is a need to improve governance generally of the forensic disciplines. The problem being that there are basically 52 jurisdictions, right? There's 50 states, DC, and the feds. And so a lot of top-down approaches aren't necessarily going to be effective. One of the things that we're doing now is we have a National Association of Forensic Science Boards that is designed to help connect the existing state-level forensic science boards and commissions together so that they can share lessons learned, so that the very successful Texas Commission, for example, can share with the new commissions in Illinois and Massachusetts, that the older commission in New York and all the lessons that they've learned, they can share around as well. And that states that are looking to do something new, for example, I'm working now with Maryland. Maryland would like to try to kind of reform how it's doing licensing and other kinds of things, have the ability to access the basic documents and things like that, and policies that would allow them to move forward. So I'm hoping that we'll be able to encourage the development of forensic science commissions and boards at the state level to help with the whole range of these issues and in general, help with governance and forensic science.
Great. So I have a two-parter for you, Rebecca. And the first is a question just for you. And, you touched on some of the common opposition arguments for change in science mechanisms. If you could speak a little bit more about that and what we should know if folks are thinking about promoting a change in science statute in their state. And then the second question, which I would like for everyone to answer, is we have this incredible opportunity to with an audience of scientists, of researchers, of attorneys, policymakers. What do you want them to do? Like, if someone is motivated to take action, what should they do?
Great. So, first speaking, and I can package these together because they're related. So, I think the common opposition is often, finality of conviction, right? There was a direct appeal, it's over, keep it moving, right? And obviously, we understand why that is so problematic. Also, questions around how can we be certain when the science has changed? And this is a real area where I think people in the room, and I know there are students here, and of course scientists, helping us to frame those arguments is always so helpful. You don't always have an NFPA 921, changing their own standards, right? The National Fire Protection Association changing their own standards, which they did in 1992. Like, that's a clear example of when there was changed science or, a changed interpretation. But there are so many disciplines where we need to better understand when science is changing and evolving, and really helping us to understand that, and helping the courts to understand that, and all the stakeholders across the system to understand that. So I would really say that's a clear area of where it would be very helpful for the community of advocates working on this. Often another one is the law should be limited to scientific disciplines that have already been discredited or undermined. What does that mean? And the law would allow anyone with a differing opinion to get back into court. So why create this mechanism? Because we'll just start hearing from anyone. So those are some of the common arguments, but I would just say, and of course, flood of litigation, right? If we create this mechanism, there'll be a flood of litigation. The courts won't be able to operate anymore. And I guess all I would say to that is California and Texas, the most populous states, have had these mechanisms in place for years, and certainly the court systems have not shut down, but we certainly have enabled justice for people. And one person is one person too many. So, but I think as far as, the audience and how people can be helpful, I think it really is a question of really helping all stakeholders, from the judicial community to lawmakers, to really understand where those key points are in our, evolution of thought around scientific disciplines.
My favorite thing to tell everybody, vote. Vote. Learn who your lawmakers are, and when they start throwing out these terms like criminal justice reform and new policies, grab that person or stand up like I do in front of everybody and ask them, what exactly does that mean? What is your vision for this? What policies are you talking about? And really focus in on what they're saying, because if we're going to make true change, we have to be the instrument that helps push it forward.
So I don't know whether, I hope I'm not unique in the audience. I am a former Congressional Science Fellow for the American Association for the Advancement of Science. I actually, through the American Physical Society and the AAAS Fellows Program, spent about a year and a half on Capitol Hill working science policy. There we go, there's another fellow, yay! And so number one is that. I think the engagement of the scientific community in the policy process, I think, is extraordinarily important. Too often, we kind of want to, a lot of scientists are afraid to communicate, afraid to be a part of this kind of a forum. You know, I just do my thing in my lab and that's the end of it. I do believe everybody should have engagement, whether they're a scientist or not, in the public sphere, but especially the scientists who have specialized knowledge. We need it because we're in a time when that specialized knowledge is more needed than ever in criminal justice and forensic science and in other areas as well. And to be able to communicate it properly. That is, that we keep and promulgate a culture where we understand what the strengths and limitations of the science are. We're able to communicate that. We're able to represent that well. That's an amazing part of what it means to be a scientist in the world in 2023, and we should embrace that and make that a thing.
Great. So over the last 2 days, a question that I've seen recurring in every panel is, what is the solution to this problem? And what I love about this panel is that we've brought some solutions to you. So for those of you who are here, those of you who are online, I hope you can play and replay this video and think about what you can do to improve the forensic science and in your state, support it, and to help prevent wrongful convictions in the future. So let's please give a huge round of applause to this tremendous panel, and thank you, AAAS, for this opportunity.